Okay, betul kita sampai defense of apa namanya defense of apa namanya intoxication kan dah habis kan? Betul tak?
Yes, sir.
Betul intoxication dah habis kan? Habis kan? Habis kan? Semua sekali?
Yes, sir. Yeah.
Okay. Okay. Bismillahirrahmanirrahim. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Assalamualaikum warahmatullahi. So for today, inshallah, I'm going to talk on the defense of consent. Yeah, defense of consent. So what is consent? There is no definition of consent in the penal code. The penal code doesn't give any definition of consent. But there is definition of non-consent under the penal code, section 90. Section 90 defines the situation whereby consent is not valid, but there is no definition of consent. So because of that, we have to look at the cases. The definition of consent as stated in the cases. And one of the cases, trying to define the meaning of consent is the case of Abdul Hamid against the public prosecutor. Abdul Hamid against the public prosecutor says, defines consent as an act of reason accompanied by deliberation, the mind weighing as in a balance the good and evil on each side. So consent,
I'm sorry, sir.
yes.
But we've done consent as well.
Wait, what?
We're supposed to be on slight harm.
Oh, side harm, Oh, okay, thank you. Why did, when I asked you just now, why did you only finish off with what they call until
Intoxication, because I thought you asked whether we've done intoxication.
Okay, thank you for informing me. Okay, let's look. Oh, now what about duress? Have you done duress?
Yes, sir.
Even duress.
Yeah.
Oh, even duress.
Yes, sir.
Oh, okay. So let's look at the slight harm. Oh, duress sudah. Oh, so we have almost finished off our syllabus now. Okay. So the defense of slight harm, the defense of slight harm. Okay. There are certain acts which are so trivial. Trivial means so small, so not important. Nothing much. It's a simple matter. It's a small matter. There are certain acts which are so trivial in nature that they should not form the basis for action in crime. The harm is so slight that it would be appropriate for the law to hold the accused criminally responsible. It will be inappropriate. Meaning, it's sometimes it is something which is perhaps it may be against the law. It may be against the law, but it is so slight. It is so trivial. It is so small matter that most people will just leave it as it is. Most people will not take any action against the the offender. For example, let's say when for example, let's say while talking or while joking, your friend slap you on your back, for example. So that is actually what is that? If it is without consent, it is an offense known as criminal force. If it is done without consent, it is criminal force. But if let's say in most situations, but of course you must be of the you must be it's not a man against a woman. If a man touches a woman, that will be inappropriate. In our culture, it will be inappropriate for a man to touch a woman in such a way. But let's say you touch your friend, you slap, you pat, or push your friend because she is while talking, for example. So most of the time, most of people will just will not take any action against the the offender or the person pushing him, because that matter is so trivial. It is small matter. And let's say the other person, the victim, that wants to take action against the offender. In such situation, the victim has one defense. This defense is known as slight harm. Many things, for example, someone, if your friend pushing you, for example, or even a stranger, for example. Let's say you want to go to your ITM, for example, for your class, for example, and you have to ride a bus, for example. You have to fetch a bus. You have to ride in a bus, for example. You have to go to your ITM by bus, for example. And then, let's say the bus is full, but you do not want to miss your class. If you miss that bus, you will be late. You will be late for half an hour, because the next bus will come in another half an hour. And then because of that, you just push against the people there to so that you will get certain place inside that bus, so that you can go aboard into that bus. By doing that, you are actually committing a crime known as criminal force. You are using criminal force against the other person by pushing your body. Using your body, for example, you are quite big, for example, and the person there, the person at the door, for example, is quite small. So you use your body, for example, the back of your body, and then push against him, so that he will go further inside and make way for you. Let's see, that is the situation. That is actually a crime known as criminal force, but it is so slight, it is so trivial, that because of the nature of the nature of taking a bus at the time, for example, because it is peak hours and it is usual for people to do that, for example, to make sure that they reach their class or their workplace at the at the time punctually. They have to do that, and that is acceptable, for example, in Kuala Lumpur, for example, or in Shah Alam, for example. So if that is the case, the victim, the small person who is being pushed further inside the bus, actually can make a police report against the person pushing him, because using criminal force against him. But the offender can use this defense. This defense is known as slight harm, because the thing that he has done, the offender has done, is so slight, so trivial, that people usually will not take any action against that kind of behavior. So this defense is known as slight harm. So it is stated under Section 95 of the Penal Code. Section 95 of the Penal Code says, nothing is an offense by reason that it causes, or that it is intended to cause, or that it is known to be likely to cause any harm, if that harm is so slight that no person with ordinary sense and temper would complain of such harm. So this is the defense under Section 95. Nothing is an offense, meaning that this is also an absolute defense. Absolute defense, meaning if he is able to prove this, then he will be acquitted. He will not be punished at all. He will not be convicted. Nothing is an offense by reason that it causes harm. It causes harm. It actually causes harm, or that it is intended to cause harm. It causes harm, or that it is intended to cause harm, or that it is known to be likely to cause any harm. he intends to cause harm, or he actually caused that harm, or he knows that by doing such act he's likely to cause harm to the victim. If that harm is so slight, it is so trivial, it is so slight that no person with ordinary sense and temper would complain of such harm. For the example that I've given to you just now, going inside the bus in the peak hours, or going inside the LRT. Apa nak naik LRT during peak hours. During peak hours, it's packed, for example. So if that's the case, then even though he's being pushed further inside the bus or inside the LRT, and that is actually a crime, but it is so slight, it is so trivial that a person with ordinary sense and temper will not complain. People will usually not complain in such situation. Of course, if let's say it is a girl and then you take advantage of that situation and then touching inappropriately that girl, that is not a slight harm. For example, let's say you go on board into an LRT full of people, and then you touch, you take the advantage of that situation because it's full pack, and then you touch inappropriately a girl beside you. For example, touching the chest of the girl, for example, that is not slight harm. That is not slight harm. That is using criminal force to outrage the modesty of the girl, of the person, and you can be punished with up to 10 years imprisonment. That is not slight harm. And also, Section 110, Subsection 1, Paragraph A and B of the Criminal Procedure Code. This is Criminal Procedure Code. Says, let's look at the Criminal Procedure Code. If the case is not of a serious nature, so Section 110 is the procedure. After after a person has made a police report. After a person has made a police report, and then the police will look at the the case, the report, and then decide whether it is a serious case or is it not a serious case. If it is not, and under Section 110, Subsection 1, Paragraph A and B, if the police feels that it is not of a serious nature, the case it is very trivial, it's not a serious nature, or there is no sufficient ground for proceeding, the police need not proceed to make an inquiry into the facts and circumstances of the report. If it is so trivial, it is so slight that no person with ordinary sense and temper will complain of such harm, the police need not make any investigation. So that is stated under Section 110, Subsection 1 of the Criminal Procedure Code. Even under the procedure, in the Criminal Procedure Code, it is not, it is, if the police feels that the case is so trivial, then it did not make further investigation under Section 110. The case in Vida Menezes and Yusuf Khan. The appellant, Mrs. Menezes, is the owner of a house in Bombay, and the wife of the first respondent, Yusuf Khan, is a tenant of a part of the first floor in that house. On January 17, 1963, one Robert, a servant of the appellant, called the wife of the first respondent a thief and halkat. On the next day, halkat ni the word in what called in their language, in Urdu or in Urdu language. On the next day, the first respondent slapped the face of Robert. This was followed by a heated exchange of abusive words between the first respondent and the appellant's husband. The first respondent was annoyed and threw at the appellant's husband a file of papers. So this is the situation. Not slap. Slap is actually it is causing hurt. That is a serious offense. But now the issue in this case, when he threw a file of papers, he threw the file of papers onto the appellant's husband. The file did not hit the appellant's husband, but hit the elbow of the appellant. He intends to to hit the appellant's husband, but instead of hitting the appellant's husband, that file of paper hit the elbow of the appellant, causing a scratch, just a little bit of scratching, just scratching through the but it is merely a paper going through his her elbow. The investigation by sub-inspector found that the appellant had suffered a mere scratch on her elbow, and then she made a police report. So the issue here was the scratch, the touching of her elbow by the papers thrown by the respondent. The injuries caused to the appellant and Robert were, in the view of the court, trivial, and the court found that the paper merely scratching through the elbow of the appellant was very trivial, was very small, was not important. It's very small, so trivial. And the case was one in which the injury intended to be caused was so slight, and that a person with ordinary sense and temper would not complain of the harm caused thereby. The court accordingly set aside the conviction and acquitted the first respondent. So the court allowed the defense under section 95. So because when the respondent threw the paper and it only hit a little bit on the elbow, it's just a paper touching the elbow, so nothing much. It's not a knife, it's not a book, it's merely a paper going through her elbow. Of course, it is criminal force. It is, the offense is actually criminal force. But because it's so trivial, it is so slight that a person of ordinary prudence will not complain. A person of ordinary sense and temper will not complain. So the court held that he was allowed the defense under section 95 of the Penal Code, the defense of slight harm. So that's all under the defense of slight harm. Do you have any question, anything that you want to ask? Okay. Now let's move on to private defense. Okay, let's look at private defense. Private defense. Section 96 of the Penal Code. Section 96 of the Penal Code says, nothing is an offense. So this is also an absolute defense. Nothing is an offense which is done in the exercise of the right of private defense. Nothing is an offense which is done in the exercise of the right of private defense. So if a person is exercising his right of private defense as allowed under the Penal Code, under Chapter 6 of the Penal Code, then he will not be guilty of any offense. That is clearly stated under section 96. A person is justified to retaliate. In the case of Mahandi against emperor, a person is justified to retaliate when he is attacked, provided that the retaliation is proportionate to the attack. If someone attack the victim, if someone attack him or a person, that person has the right to exercise his private defense and retaliate by counter-attacking the person attacking him. So this is stated in the case of Mahandi against emperor. For example, let's say someone trying to attack A or push A, for example. Someone pushes A, for example. So A has a right to defend himself by pushing B, pushing the person, what I call pushing him. So this is the right of private defense as allowed under the law. Section 97 of the Penal Code says, every person has a right to defend A, his own body. So the right of private defense under Section 97, the right of private defense under Section 97 is divided further into two. A, the right of private defense to defend his own body, the body, or another person's body. For example, his wife, for example, his friend, for example, his father, his mother. He has a right to defend his body or his family member or even a stranger. Against what? Against any offense affecting the human body. What kind of offense affecting human body? For example, against murder, for example, someone trying to kill him. So he has a right to defend his body against being killed by another person. Or, for example, causing hurt. The offense affecting human body, causing hurt. So someone trying to hurt him, he has a right to defend his body by stopping that person or counter-attacking that person. Or another example, for example, someone trying to use criminal force against him. So he has a right to defend his body under Section 97, paragraph A. Or let's say she is someone trying to rape her, for example. So she has a right to defend her body against the offense affecting the human body. What is that? What is that offense? Is known as rape, against rape. So this is his own body and another person's body against any offense affecting the human body. So that's the first one. The second one, every person has a right to defend the property. The first one is the body. Someone trying to attack his body, trying to kill him, trying to cause hurt to him, trying to cause grievous hurt to him, trying to rape her, for example. All these offenses against human body, he or she has a right to defend him or herself. And another another private right, private defense, is the defense of his property. Every person has a right to defend the property of himself. Now they defend property. What kind of property? It can be a car, for example. Someone trying to steal his car. Someone trying to burn his house, for example, his house. Someone trying to burn his house. The property of himself. Every person has a right to defend the property of himself. And that property may be his own property or any other person. So it can be his father's property. His father's house, for example. Someone trying to break into his father's house, for example. Or someone trying to steal his father's car, for example. Someone trying to steal his brother's motorcycle, for example. So this is the property of another person. Or even a stranger. You find someone trying to steal the property of another person. He doesn't know that person, but he knows that that person is is trying to steal another person's motorcycle, but he doesn't know who's the owner of that motorcycle. It doesn't really matter. He still has a right to defend the property even of a stranger. So the property of himself or any other person, either movable or immovable. It is not limited to movable property. Movable of, for example, a car, a motorcycle, a bicycle, a laptop, right? A bag, for example, money, for example, or immovable. Immovable, for example, a house, for example, a land, for example. So someone trying to break into his house, for example, or someone trying to steal property in his house, for example. Any offense under the definition of theft, immovable, so it can be movable or immovable property from any offense under the definition of theft, someone trying to steal his property, or robbery, or mischief. Mischief, for example, someone trying to burn his car, for example, that is mischief. Someone trying to burn his motorcycle, for example, so that is mischief. Someone trying to burn his house, for example, that is causing mischief. Or criminal trespass. Criminal trespass, someone trying to enter into his house without his permission. So that is criminal trespass. Or someone trying to enter into his land without his permission, for example. So that is criminal trespass. Or attempt to commit those offenses, or attempt to commit theft, attempt to commit robbery, attempt to commit mischief, attempt to commit criminal trespass. So he may use any means necessary in order to stop that person from harming his property. Section 98 of the Penal Code says, the person has the same right of private defense against an act which would be an offense, but it is not an offense because of youth, want of maturity of understanding, unsoundness of mind, intoxication of the person who committed offense, and misconception of it. What is this? What does Section 98 mean? What does Section 98 mean? Meaning that, okay, we have, I've already explained just now that a person has a right to defend his body, and also his property. Okay, against what? For example, let's say we are talking about, someone trying to harm his body, someone trying to cause injury to him, someone trying to cause hurt to him. So hurt is an offense. Causing hurt is an offense under the Penal Code. If you look just now, let's look at the provision just now. If you look at the provision just now, every person has a right to defend his own body, his body. Against what? Against an offense affecting human body. So if you look here, against what? Against any offense affecting human body. It must be the person must be committing, the person that he's trying to protect, that he's trying to the person that is trying to harm him must be doing something which is an offense against affecting the human body. It must be an offense affecting human body. For example, causing hurt, for example. He must be doing an offense. The person A, for example, let's give an example. A, for example, A is trying to harm B, for example. A is trying to cause injury to B. So A here, when he tries to causing injury to B, that is an offense affecting the human body under Section 321, kan? Causing hurt. Under Section 321, the offence of causing hurt, voluntarily causing hurt, under Section 321 of the Penal Code. So the A is committing an offence affecting the human body to B, against B. So B here, under Section 97, because A is doing is committing an offence affecting the human body, he has a right to defend his body by counter-attacking A, by attacking A. So this is allowed under Section 97. Okay. Back to Section 98. If you look here, he must be doing, A here must be doing an offence affecting human body. Back to Section 98, the problem here is that, what if A is not guilty of committing an offence affecting the human body? For example, because he is insane, for example, he is of unsound mind. If that person is A, for example, is unsound mind, is a person of unsound mind. Let's say A, the person attacking B ni tadi, is a person of unsound mind. So under the law, even though he's trying to attack B, or he's trying to kill B, for example, but he has not committing any offence. He's not guilty of committing any offence. Why is he not guilty of committing any offence? Because he is of unsound mind. So he has no mens rea. Or because he is under misconception of fact. For example, he believes that B is trying to rape C, for example. Because of that, he is trying to attack B, believing that B is trying to rape C. So that he is under misconception of fact. Or one of maturity of understanding, or youth, or he is below the age of 10, for example. The person trying to attack him is below the age of 10. So he is not guilty of any crime under the law, because of the provision of Section 982, saying that a person below the age of 10 is not capable of committing any crime. So now the question here is that, what if the person is not capable of committing a crime because he is below the age of 10, for example, or he is a person of unsound mind? So does B here has a right of private defense against that person, that particular person, against A? So that is the question. And that question is answered by Section 98. Section 98 says the person has the same right of private defense against an act which would be an offense, but it is not an offense because of youth, because that person is below the age of 10. Or one of maturity of understanding, that person is not capable of understanding because, for example, he is mentally retarded, for example. Or he is of unsound mind, he is insane, for example. So he's not capable of, he's not guilty of any crime. Or intoxication of the person who committed offense. He's intoxicated, someone spiked his drink, for example, with malice. And then under misconception of fact, he believes that he's attacking, A is attacking B, believing that B is trying to rape a woman, for example. So he is doing something which is not wrong because he is under mistake, under misconception of fact. Even though that is a situation, B here has the same right of private defense in order to protect his body, as if that person is not a youth, is not of unsound mind, is not under misconception of fact, meaning that he has the same right, despite the fact that that person is not capable of committing a crime because of his mental incapability. Incapacity. So that is what is meant under Section 98. Do you get it? And then Section 99 provides restrictions of the right of private defense, restriction of rights of private defense. Section 99 provides 4 restrictions on the right to exercise private defense. There are 4 situations whereby a person has no right of private defense. This is restriction, meaning that he has no right of private defense under these 4 situations. Number 1, against a public servant acting under the color of his office. For example, if it is a public servant trying to harm him, under, for example, under a mistake, for example, he has no right to defend, to exercise the right of private defense against that public servant. Of course, there are exceptions. We see later on. So let's say if it is apprehension of death or grievous hurt, that he still has a right even against a public servant. But generally, if it is a public servant acting under the color of his office, for example, let's say, let me give you an example to make it easier for you to understand. Let's say you have not committed an offense. You have not committed, let's say it's not you, let's say A. A has not committed an offense. Let's say A has not committed any offense. But a public servant, let's say a police officer, under a mistake, thought that A here, let's say the public servant, the police officer is B. B thought that A is trying to commit offense of theft, or is trying to commit offense of robbery, for example. But that's not true. But he is under a mistake, for example, and he is using his power as a police officer, for example, and the offense is supposed to in his view is happening in his view at the time. So he is trying to arrest A here. So B is trying to arrest B, then tries to arrest A. But in actual fact, A has not committed any offense. So that is a wrongful arrest on the part of B. Even though that is a wrongful arrest on the part of B, A do not have any right of private defense against B. That is stated under section 99. So if let's say the A is trying to B is trying to arrest B by using his power as a public servant under mistake, for example, A has no right of private defense against the police officer, even though the police officer has made a wrongful arrest. This is stated under section 99. Of course, later on, he may claim for the compensation for wrongful arrest. That is another matter. But under the law, what we're talking here is a right of private defense. Under the law, A here has no right of private defense against that public servant who is acting under the color of his office, even though he may have acted under a wrongful misconception or under a wrongful belief. And the second situation, against a person acting under the direction of a public servant. So this is quite similar to A, but this is a person acting under the direction of the public servant. C, if there is time to recourse to the protection of the public authorities. If there is a time to seek the help of public authorities, then he has no right of private defense. For example, let's say someone inform him, call him, for example, telling him that he is going to his place and will kill him, for example. He will come tomorrow, for example, to kill him. And then he prepare with all his weapon, or for example, a gun, in order to counter attack, in order to protect himself by killing the person that if that person come to see him. That is not allowed under the law. What he should do is that he should go to the police station and make a police report, and then the police will take care of that matter. It's not allowed that for him to exercise his right of private defense if there is a time to recourse to the protection of the public authorities, because it is not the right to take the law into his own hands. It is the right of private defense, not the right to take the law into his own hands. And lastly, number 4, the fourth restriction, he must not cause more harm than necessary. He must not cause more harm than necessary. For example, someone pushing him, and then he pull out his knife and then stab onto the neck of that person. So that is, of course, that when that person pushing him, that is an offense, and he has a right for defense, but he should not cause more harm than necessary. What he should do is that he should kick that person, or he should punch that person, or he should push again that person, or even using a stick and then knock onto that person's body, for example. That may be allowed, but not to kill that person. If he kills that person, he has caused more harm than necessary, because that person is merely pushing him. Of course, pushing him is an offense, and he has a right of defense. It doesn't mean that he doesn't have the right of private defense. He has the right of private defense, but not to the extent of killing that person. So that is what is meant by he must not cause more harm than necessary. That is restriction number 4, as stated under section 99 of the Penal Code. Okay. It's 8:54. So let's take a 10 minutes break. So we'll continue, inshallah, at 9 5 minutes past 9. 9:05 minit. 5 minutes past 9. We'll continue at 9:05. 9:05, inshallah.
Sir,
Yes.
can you send these slides to the group?
Okay.
Okay, thank you, sir.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi. So let's look at the what you call the first one, the first exception, the first restriction, the first restriction under section 99 paragraph A. Public servant acting under the color of office. There is no right of private defense against an act which does not reasonably cause the apprehension of death or grievous hurt. So the first requirement under paragraph A is that the act of the public servant does not reasonably cause the apprehension of death or grievous hurt. Meaning that if, let's say, the public servant just now trying to arrest him, for example, or trying to harm him, for example, and he apprehends that if he doesn't do anything, if he doesn't stop that public servant, he will be killed, he will die, or he will be grievously hurt. For example, that public servant is trying to shoot him with his gun, for example. So if he doesn't do anything, then he will die, or he will be grievously injured. So if that is the situation, he still has a right against that public servant in order to protect his body against the harm done by the public servant. So that is the requirement. The requirement under this, it must not reasonably cause the apprehension of death or grievous hurt. So if it does not cause the apprehension of death or grievous hurt, then he has no right against that public servant. If it is done in good faith, there is another requirement is that the public servant must have acted in good faith. And another requirement, he must act under the color of his office, not in his personal capacity, but under the color of his office, meaning in performing his job as a public servant. Though he may not strictly justified by the law, though his act is not justified by the law. For example, he is trying to arrest A, but he is under mistake. In actual fact, he is not supposed to arrest A, but he is supposed to arrest B. But he wrongly believed that A is B. Because of that, he arrests A, and that is against against the law. But even that is the situation, because A here is acting under the color of his office. B, the victim has no right of private defense against the public servant. If what they call the public servant fulfills all the requirements under paragraph A. What are the requirements? Number one, the act of the public servant must not cause the apprehension of death or grievous hurt. Number two, the public servant must have acted in good faith. Number three, he must act under the color of his office. So if all these three requirements have been fulfilled, then only the victim has no right of private defense against the public servant. But under explanation 1, but it will not deprive his right if he doesn't know or have reason to believe that the person is a public servant. That's why the public servant exercising authority, most of the time they have their own uniform. Kan? For example, police officer, they have their own police uniform. Let's say MBSA, Majlis Pembandaran Shah Alam officer, for example, they have their own clothes and their own uniform. Or immigration officer, they have their own uniform. Custom officer, they have their own uniform. This make sure that the person knows that he is acting under the color of his office. He's performing his duty, his job as an immigration officer, or as a police officer, or as an immigration officer. That's why they have their own uniform, to make sure that the other person knows that he is performing his duty. Because if the other person doesn't know that fact, then under explanation 1, he still has a right of private defense against the public servant. The case of Babu Jivaji and Mulji Dayal. Babu Jivaji and Mulji Dayal, the conviction against the accused, a police constable, was reversed on the ground that the accused was on duty and acting under the color of his office, even though he may not be strictly justified by the law. It was held that the complainant had no right of private defense, as the accused was a public servant acting under the color of his office, and his act was not one which caused the apprehension of death or grievous. So what happened in this case was that the victim here was wearing certain clothes. This was in 1888. Certain clothes, certain types of clothes, expensive clothes. The poor, most of the time, they could not afford to wear expensive clothes, and he was wearing expensive clothes at the time. And the police officer thought that police officer in the police uniform thought that he was using a stolen clothes. So he was trying to arrest the victim. He was trying to arrest the victim. And in actual fact, it was his own clothes. He had not done any criminal act. It was his own clothes. And then he tried to stop the police officer from arresting him because he had not done any criminal act. So the question was that whether when he attacked that police officer, whether he had the right to do so. The police officer had done something which was wrong. He had mistakenly thought that that person was wearing a stolen clothes, so he was trying to arrest the victim. So the question was that whether he had the right of private defense against that police officer. The court held that no, he had no right against that police officer, even though the police officer was was acting under a wrongful belief. Because of the provision of section 99 paragraph A. And the second exception is under section 99 subsection 2. There is no right of private defense when an act does not reasonably cause the apprehension of death or grievous hurt, if done or attempted to be done under the direction of a public servant, acting in good faith under the color of his office, though that direction may not be strictly justifiable by law. So this is quite similar. This is very similar to subsection 1. The only difference is that this is under the direction of a public servant. Subsection 1 is under a public servant acting under the color of his office. However, a person is not deprived his right unless he knows or has reason to believe that the person doing the act is acting by such a direction, or if he has authority in writing, unless he produces such authority when demanded. Explanation 2 to section 99. Meaning that if, let's say, he is acting under the direction of public servant, he must make known to the other person that he is acting under the direction of public servant. For example, he has a letter of authority from the public servant. He must show that letter to the person that he's trying to arrest, for example, that he's trying to harm, for example. And number 3, subsection 3, time to recourse to public authorities. There is no right of private defense in cases in which there is time to have recourse to the protection of the public authorities. This was held in the case of public prosecutor against Ngui Ming Xian. In the case of public prosecutor against Morzuki Saleh, public prosecutor against Morzuki Saleh, this is interesting, whereby the accused was charged for murder. The accused was charged for murder. But in this case, there were 2 incidents. There were 2 separate incidents. The first one was there was a quarrel between the accused and the deceased. The accused quarreled with the deceased. The first incident. They quarrel, they quarrel, and then the deceased went away. This deceased went away. They quarrel, the accused and the deceased quarrel. They quarrel. brother searching for the accused. That is the second, and then the second incident happened. In that second incident, the accused killed the victim, the deceased. So now the question in this case was that there was a gap of half an hour between the first incident and the second incident. So the argument by the public prosecutor was that because there was a half an hour gap, the public prosecutor argued that during that half an hour, he should have gone to the authorities. He should have gone to the police station, make a police report, so that the police will protect him, not for him to take action on his own by killing the deceased. That was the argument. But the court held that the first and second incidents were separated, although they were connected. When he was attacked during the second incident, he has no opportunity to escape, and he has no prior knowledge and could not have expected that the second incident would have occurred. The accused had properly exercised his right of private defense. So in this case, even though there was a gap between the first incident that they quarreled and the second incident that the accused killed the victim, during that gap, he did not know, because even though he did not seek the police protection, but at that time, he did not know that the victim or the deceased, the victim, would come again and attacking him in the second incident. He did not know that second incident would have happened. Because of that, the court held that he was still allowed the defense, the right of private defense of the body. Because he did not know that the victim was going to attack him in the second incident. If he had known that, then he would not be allowed the defense under section 97, subsection 1, because he should have gone to the public authorities, have gone to the public authorities, the police station, make a police report. But here, because he did not know that the second incident was about to happen, because of that, the court held that he was still allowed the private defense of the body, and subsection 3 was not applicable in this case. And lastly, number 4, he should not cause more harm than necessary under section 99, subsection 4 of the Penal Code. In exercise of the right of private defense, the accused should not inflict more harm than necessary. He should not inflict more harm than necessary. In the case of public prosecutor against Halim Din, the accused had fired a gun towards the deceased during the Islamic Religious Council raid because he thought that the deceased was a member of a gangster group. The court held that the accused had exceeded his right of defense in using reasonable force when he fired the gun against the deceased who was only armed with a piece of wood. So what happened in this case was that Halim Din, Halim Din in this case was a police officer. He was a police officer in rank inspector. His rank was an inspector at the time. He was a police inspector with the rank of inspector. So at that time, he committed an offense. He was suspected of committing an offense known as close proximity with a girl. Close proximity with a girl is what they call khalwat. He was there was a raid by the authorities, by the religious authorities, suspected him of committing an offense of khalwat, or close proximity with a woman who was not his wife and who was not his mahram. And then he was scared. I do not know what happened, but he was scared, perhaps. And then he tried to run away. But when he failed, he pulled out his gun and killed one of the members of the gang of raid, gang. So the question in this case, he was trying to raise the defense of private defense. He said that he was exercising his right of private defense. But the court held that that person, the deceased, was only armed with a piece of wood, and he was not trying to kill him. There was no apprehension of death or grievous hurt, and he was not even threatened to hurt the victim. Because of that, the court held that he, based on section 99, subsection 4, he had inflicted more harm than necessary. It was not necessary for him to kill the victim. So when he did that, he had done more harm than necessary. Because of that, he was not allowed the private defense of the body. The right of private defense of the body, this is important. Let me see. This is a long topic and it's very important. This topic is very important. The right of private defense of the body may extend to causing death in certain situations, because it's quite a lengthy topic and it's very important. I think we stop now because I want to continue up until the end of everything in one, in one lecture, because I don't want to explain on this, partly this, and then continue next week. It's better that I continue from the very beginning up until the end in one whole full lecture. So I think we stop now. I will continue with section 100 of the Penal Code. This provision provides the situations whereby a person may go to the extent of causing death in order to protect his body or the body of his family against any offense against affecting the human body. Okay, I think we stop now. Do you have any question before we end this? Before I end this lecture, do you have any question? Anything that you want to ask? Semalam, I'm sorry about yesterday. I could not attend the tutorial yesterday because of the interview. I have to interview the new applicants, the new students. I think yesterday around 27 of them. Altogether, I think 700 or something like that. 700, but I'm in charge with to interview around 27 applicants. So that's why the whole full day, starting from 8:30 up until 5 o'clock yesterday. But it's online, online interview actually. Okay, any question? Anything that you want to ask? If you do not have anything to ask, then we stop now. Inshallah, I will continue next week with the private defense of the body and also the private defense of the property, inshallah. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, sir.